The competition law jurisprudence is evolving, and as you know, there are sort of three parts to it. There's restrictive agreements as a cartels, and both sort of horizontal agreements as well as vertical agreements, which is one part. The second is abuse of dominance, and the third is merger control or combination control. And all of them are sort of moving forward apace. Of course, the combination rules were brought into force roughly about 2 years ago after a long debate. And it's a mandatory provision, and there's a suspensory regime for about 210 days. So what it's meant is that all M&A transactions which are above a particular threshold or don't fall within some of the exemptions require a mandatory notification and approval by the competition authority. Roughly about 115 notifications have been done since the regulations came into force. Most of them, most if not all, have been approved, some in different time frames. Process has been so far quite efficient if you sort of take a step back and take a big picture. Two Form 2 filings were involved, and we were lucky enough as a firm to have been involved in both of them. Form 2 is a sort of long form filing where there's a much more detailed analysis. It's one of the biggest developments in the M&A space in India, and it's something very exciting in terms of how we are seeing the law evolve on this. There have been a number of important investigations on cartels as well as in abuse of dominance, and it's the sort of new big thing in the Indian sort of corporate milieu. The kind of penalties that can be levied are unheard of. The cement cartel, for instance, is a case that's going on, was levied about $1.5 billion worth of fines, which is absolutely unheard of in anything else, on any other law in India before that. So it's woken up corporate India. They're doing audits. They're getting the planning for how they should be sort of dealing with this space, and they're sort of spending serious money talking to firms like ours and getting their act together. I think most regulators, of course, are always learning, but I think the Competition Commission in India has scaled up a lot in the last few years. They are also constantly talking to regulators outside, whether it's the EU or the US, and learning from them. They do a lot of training. They get experts from overseas to come and train them. Compared to the size of what they need to regulate in India, they need to be bigger. They should probably hire a bunch of lawyers, and that will expedite some of the processes as well. But that being said, I think they're doing a good job. So international M&A would be picked up under Indian merger control law if there was a nexus with India. So you can have an Indian tail stopping the global dog in sort of big global M&A with a sort of an Indian piece. You will need to mandatorily get that approval. But that's not atypical in many markets as well. So companies and businesses which are multi-jurisdictional have separate pieces in different markets. You have to go through a comprehensive jurisdiction by jurisdiction competition law compliance. So I don't think the implications of this need to be overstated. I think multinationals understand that you have to deal with several regulators. Then comes a question of other kinds of business practices, and again, if they have an impact in India in terms of sort of competitive behavior, why should they not be picked up? Why should an international cartel which has an impact in India not be covered under? So I think it's probably an unfair criticism from the rest of the world of our regulator being extraterritorial in their reach. Why not?